So, my name is Peter Nolan. My calling is Peter Andrew Nolan. I have asked David Dunkley, I have told David Dunkley that I will enter this courtroom if I have all my inalienable rights intact. David Dunkley has said that I do not have all my inalienable rights intact. I do not enter this courtroom until such time as I have all my inalienable rights intact. And your agreement, Mr. Dunkley, to that? No, sir. I will have a seat when you agree I have all my inalienable rights intact.
Mr. Bevan, do you rely on the amended response filed the 21st of April 2009?
Your Honour, I have a new order to hand up, which bears that. I'm not sure if you received my case outline.
I did.
There is one additional order on this minute order in relation to an county Jersey.
In that account?
Yeah, Australian dollars, $1,458 Australian dollars, using conversion rate of 1.6 euro.
1400.
Yes.
Alright, so she relies on the minute of order. The affidavit sworn the 10th of November. The financial statement, which was sworn on the 20th of November.
That's correct.
Is that the documents?
They are.
Now, Mr. Nolan, there was filed for you an application for final orders on the 3rd of December 2007, and there was also filed on that day an affidavit that you swore on the 13th of June 2008, and a financial statement that you swore on the 28th of November 2007. And there don't appear to be any updating documents since then. Are you relying on any other documents?
I'm not relying on any other documents to do with the Australian Federal Magistrates Court.
You're relying on those or not on those?
I'm not relying on those documents to deal with this situation today, and the question I have is, may I take a seat with my inalienable rights intact?
You can take a seat whenever you like.
When you agree that my inalienable rights are intact, I will take a seat, Your Honour.
It's matter for you as to whether you keep standing. So those documents aren't relied on by you. If that's the case, then you won't have any documentation before the court.
I have documentation to present before a common law court, Your Honour, but I'm not going to enter until such time as you agree to the contract that my inalienable rights are intact.
Well, it's a matter that you either give me the documents now or the case would proceed on an undefended basis.
You have no right to proceed with the case on an undefended basis, David. I have submitted my claim of right to the Queen, the Prime Minister, the Attorney General and the Governor General, and they have consented by acquiescence that you do not have a right to provide judicial adjudication services to me unless I consent.
Yes, well, so you're an intelligent man and you know that that's a nonsense.
Well, if that is a nonsense, David, you are going to have to sign an affidavit under full penalty of perjury, full commercial liability, to say that it is a nonsense. Are you willing to sign such an affidavit?
No, I just said that it is a nonsense.
Well, what you say doesn't matter. What matters is what you're prepared to put on an affidavit, David.
All right, so there's no documents on which you seek to rely.
I have documents on which I seek to rely, but you have not agreed to the contract that I can enter the courtroom with my inalienable rights intact.
So you either hand me the documents now or the matter proceeds on an undefended basis.
Well, if you proceed with the matter on an undefended basis, David, I will charge you 1 million ounces of gold for enforcing an adjudication process on me that I have not consented to as a sovereign. I stand here before you as a sovereign of the nation of the land known as Australia, and I do not consent to your adjudication services in any way, shape or form. And I have plenty of witnesses who know this.
All right, thank you. Then the matter proceeds undefended.
Well, you will be charged 1 million ounces of gold for doing this, David. Do you agree to that charge?
Charge whatever you like.
Thank you for agreeing to the bill, David. Your audience here may wish to know, why is it that a man cannot enter the courtroom with his inalienable rights intact?
The audience here observes that you're already within the courtroom, sir. All right. Then, Ms. Bevan, you better address me in respect of how we would get to a set of circumstances that would mean that your client gets the totality of the asset.
In order to do that, Your Honour, I must tender a reasonably significant amount of documentation. In relation to Button Keller and Weir principles, my case is that the husband, by failing to disclose his assets, has left the court in a situation where, as those cases say, you should not be unduly cautious in making an adverse finding in favour of the innocent party. In addition, Your Honour, the husband himself, in various emails, has made reference to his own income earning ability, in reference to his, in effect, disruption of the company of the parties, Instant Business Intelligence. There are other factors to take into account with regard to the Irish proceedings. My client's evidence is those Irish proceedings are now concluded and cannot be reinstated.
Well, they can't be because, I mean, this is the venue for the hearing.
It is, and this is the appropriate jurisdiction, I must admit, Your Honour. Your Honour, there's also emails from the husband in which he makes reference to having removed certain amounts of money, such as €7,000 and €10,000 out of the jurisdiction, that being the jurisdiction of Ireland.
All right, we better tender that material.
Thank you, Your Honour. I have on the front of it a list of those documents. I estimate that it will take approximately an hour to read. However, I can indicate that in relation to the husband's emails, although it's certainly outside of the usual practice, those emails are quite lengthy and I have put highlights around the relevant sections. I don't ask you to read the whole of the emails, but simply those highlighted sections.
So, the material that's produced in the blue black folder, you're seeking to tender that?
I am, Your Honour.
Mr. Nolan, there's sought to be tendered before me some material in a binder. Do you wish to be heard in respect of the tender?
I do wish to be heard, sir, and I wish you to agree that I can approach the court with all my inalienable rights intact.
So, do you consent to the tender of the documents?
No, I do not consent to the tender of the documents, David.
On what basis
I don't consent to the tender of the documents on the basis that I have not been given the opportunity to enter the court with all my inalienable rights intact.
That's not a legal basis for the tender not to proceed, sir.
That's the lawful basis for the tender not to proceed, David. We are in common law jurisdiction, David.
And on the basis that there's no objection that is sustainable at law, I mark as Exhibit A the material in a ringback folder. Yes. Anything further, Ms. Bevan?
Would you have my submissions now, or I can...
I know, I better read all of that material.
Thank you.
All right, we'll adjourn while I go off and read.
All stand, please. This honourable court stands temporarily.
Now, thank you.
I would love to do that now, David, as long as you will agree that I can enter between these two gates with all my inalienable rights intact, in particular my property rights.
Yes, all right. So if you're going to produce them now, please.
When you said yes or right, do you mean that I may enter with my property rights and my inalienable rights intact, please, David?
No, I don't mean that.
May I ask you a question then, David?
No, are you going to produce the documents in answer to the notice to produce?
So I want it recorded that I asked politely, may I ask David a question? And he said no.
Are you going to produce the documents?
Is your oath in the courtroom today, David?
All right, I take it that means that you're not producing.
And I note for the audience that David has refused to answer the question, is his oath in the courtroom today?
So there's no documents in answer to the notice to produce.
There are documents in answer to that notice, David. However, I will only present those documents in the case that my inalienable rights are intact.
Yes, Ms. Bevan.
Thank you. Your in the documents produced tendered, there wasn't a reference to the €10,000, I believe. I have one email and one letter to tender in addition. In relation to that. It's only the other part of that email that's in regional.
Mr. Nolan, there's produced or sought to be tendered an email from Sarah Bevan to SBA Mail dated the 25th of November 2009. Do you want to be heard about that being marked as an exhibit?
David, I would like to participate in a friendly and peaceful way in this conversation. However, I'll only participate in this conversation with my inalienable rights intact. By the way, I wish to declare that Mr. Peter Andrew Nolan is a corporate strawman fiction, and I am the primary creditor and secured party for this corporate fiction. You may call me Peter, David.
Then I mark as exhibit B the email from Sarah Bevan dated the 25th of November 2009 to SBA Mail. Mr. Nolan, there is a letter from the Royal Bank of Canada to Mrs. J. Nolan dated the 20th of March 2008 that sought to be tendered. Do you want to be heard about that?
David, I've asked you to please call me Peter. Mr. Nolan is a corporate strawman. It's a dead entity. I will speak as Peter Andrew of the Nolan family, the primary creditor and the secured party for the corporate strawman, Mr. Peter Andrew Nolan.
And there being no objection, I mark as exhibit C the letter from the Royal Bank of Canada dated the 20th of March 2008 to Mrs. J. Nolan. Ms. Bevan, in reading the material, there's an email called dublinolans@gmail.com. I presume that's your client's email.
It is your own, yes.
And then there's some emails to a Bruce at GSC
one ATAC of $7,000.
That's the money that was transferred.
€7,000, yes, was. And the net is underlined on the two last pages.
Yes.
Your Honour, the effect of the orders sought by my client, if the ABACs are taken into account, and I'll address you on those shortly, effects a split to my client of the assets of 83%, 83.3 to be precise. My submissions take two alternative approaches, or indeed a combination of both. That is, that these orders are warranted on the basis of a Black and Kellner or Weir type approach, as I highlighted earlier, that being that the court should not be unduly cautious in making findings in favour of my client and the sort of party. The alternative is that there should be a significant adjustment pursuant to section 75(2), specifically in relation to subsection B. Your Honour, in relation to the assets, the Australian assets and the relatively minor assets in Ireland are easy to identify. There is also, the husband asserts in emails, a loan from his brother. The wife has given evidence that that loan was in fact a gift. And the husband's own emails, as contained in the tender documents, refers to that amount not needing to be paid back.
It's the previous contribution that comes in on his side.
You do, Your Honour, and I'll address all contributions in that relation, in that respect when I get to it. But given that the husband has not put any evidence with regard to the amount of the loan, or the interest on the loan, or the terms of repayment, and also given the nature of his emails as contained in the tender Exhibit A, my submission is that this is not a loan. It should not be treated as a loan of the parties. In fact, it's just simply a contribution issue that I'll come back to. You're in relation to the Black and Kellner considerations. You have before you emails from the husband where he refers to removing €7,000 out of the jurisdiction. He also refers to paying that amount to a colleague in Germany, as he says. You also have the email Exhibit B, which refers to him removing €10,000. He says to apply it for the statement of family. My client's evidence says different, and in fact my client's evidence is the only sworn evidence you have before you, Your Honour. In addition, Your Honour, there was also what I would submit was a very significant asset, that being the company Instant Business Intelligence. My client's evidence is clear that that business traded well, afforded them a very decent income.
No, I don't have any figures about it.
You don't?
There's no profit and loss statements. There's no
You have-
taxation returns.
You have nothing in that regard, Your Honour. My submission in that respect is that you cannot know anything about the company. In fact, the company is now dissolved.
Dissolve, sort of.
But in any event, there's no means by which that this court can say, I consider it had at some stage a value of X. That,
I mean, it could simply just be a trading company that they conducted a business in. It had no other intrinsic value of its own.
as in just a simply income earning vehicle,
Yeah.
it could, Your Honour, but it also could have been a significant asset itself. Tied in with the company is the reference the husband makes in various emails to the software, that he has software, and one of his emails refers to no court can force me to sell my software. My submission in that regard, Your Honour, is that he's making a concession that there is an asset. Again, you have absolutely no means of knowing what that asset is worth, and that is because of the husband's complete failure to disclose any relevant material in this case, Your Honour. You're in circumstances where you have no knowledge of what the asset pool is. This is a case in my submission that falls clearly within the guidelines set out in Weir and Weir, and in my submission should give you, or should lead you to not be cautious at all in making findings in Honour, in respect of the ADVACs, it's my submission that where you have, in effect, concessions by the husband, that those amounts have been removed for his own purpose, have not been expended on my client's evidence for the sake of the family, but presumably have been used for his own personal purposes, or simply, as he says, paid to someone else, that being a colleague in Germany, then the appropriate course is to treat those as ADVACs rather than as some sort of wastage consideration under Cavalli. Your Honour, in relation to, actually I'll come back to the Cavalli issues later, Your Honour. In relation to those ADVACs, there is then the consideration of whether they are to be treated as an asset rather than under Section 75(2). In that regard, given that the amounts are clearly identifiable, and my client's financial statement sets out the means by which she has converted the amounts to Australian dollars, that being 1.616, I believe, it is appropriate, and in fact is really the only course open to the court in respect of how to treat those factors. Your Honour, in relation to the contributions, my submission is that this is a case where there should be a 55-45% split in my client's favour. Your Honour, the husband, if he was to present a case, might have two factors that he could argue in relation to contributions. That being that he provided support to the wife's two older children from a previous relationship.
A Robert Rob type.
Sorry?
A Robert Rob type.
However, that's mitigated by the fact, Your Honour, that my client received child support from the children's father, and they were only resident with the parties for a limited part of the marriage. The other factor, Your Honour, is the gift from his brother. He said it's a loan, but as my submissions made earlier, it's appropriate to treat as a gift. My client's evidence is its amount of $15,000 that was advanced very early in the relationship. On the basis of it being a relatively limited amount, and the amount of time and the nature of the contributions that have flowed since that time, my submission is it would really have little, if any, weight pursuant to his and his considerations, Your Honour. On the contrary, Your Honour, my client has made significant post-separation contributions. And I should add, when I'm jumping to post-separation, apart from those two factors that I've just mentioned, I would say that the contributions during the marriage would generally be considered 50-50. The husband was the breadwinner, my client was the care of the children and the domestic duties. She did that, and that's how the parties organised their lives. It's a clear case where, apart from these other factors, it would otherwise be a 50-50 case, Your Honour. Since separation, my client has continued to care for the children and has continued to make all payments for the care of the children. She's given evidence that in caring for the children, she must pay private school fees. And she's now also supporting Josephine, the older child, who is now at university.
She's over 18.
Sorry?
She's over 18.
She is over 18.
She's a special needs child.
She's not a special needs child now. I will come back to her in relation to Section 75(2), Your Honour. In addition, the contributions that my client has made post-separation, in my submission, have been made more onerous by the conduct of the husband. The husband has embarked on a course of conduct which is designed, or I'll draw that. The husband's embarked on a course of conduct which has had a significantly negative effect on my client. She says in her affidavit that she's received an extraordinary amount of emails from the husband. And on that point, Your Honour, I must correct one point in my client's affidavit. She says she'd received what numbers in the thousands. Since swearing the affidavit, she's taken the arduous task of actually counting those that she still has, not knowing if any were deleted when the husband accessed her account. And she has counted 550. That doesn't include the emails sent by the husband to various friends and colleagues and family members. Whatever the number, whether it's 550 or in the thousands, it is an extraordinary number of emails, all taking a to deal with the treatment she's had at the hands of the husband. Your Honour, as you'd be aware, Cannon and Cannon gives authority to where, in circumstances where there's been domestic violence, but not only domestic violence, also other conduct, which is not limited by description. The factors such as those should warrant a consideration of weighting the contributions in favour of the, essentially the victim. Your Honour, if ever a case fell into the category of conduct which is designed to, or which has led to making the innocent party have a more onerous job in doing their day-to-day life, this is the case. The number of those emails, the nature of those emails, the widespread nature of those emails can only have an effect on my client. Admittedly, you don't have expert evidence before you, but in my submissions, it's a very clear-cut case that by simple common sense, the effect of those must have had on my client. Your Honour, in relation to Section 75(2) factors, my submission is that there would be a very weighty adjustment in my client's favour. If we started from a proposition of 55-45 contributions, my submission would be that it would be appropriate to adjust perhaps even by up to 40% in my client's favour. Your Honour, the subsection B refers to the income and earning capacity of the parties. The husband, throughout his emails, has referred to his income earning capacity. In one of his more recent emails, he's referred to the ability to earn €200,000. That, in rough figures, equates to, 30 figures in my head, about 320,000 Australian dollars a year. He's referred to his consulting fee of €1,000 a day, which is 1,600 approximately a day, Australian dollars a day. If you don't consider that the property, that the business is indeed property, and instead was an income earning vehicle, the fact of the husband's income earning during the relationship suggests that he now has that earning capacity now. Whether he chooses to exercise that or not, as a result of other conduct that he chooses to take, is a matter for him. However, he has that capacity. Your Honour, in addition, my client has the care of the younger child of marriage, who's under 16. As her evidence says, she's required to pay private school fees for him, and also maintain him in the usual way. In addition, subsection D refers to the commitment to support others, as does subsection E. She's given evidence that she's paying Josephine's university fees. As someone on a student permit, she has limited work rights and therefore limited ability to support herself. In addition, Your Honour, subsection K refers to the effect of marriage on the earning capacity of the party. My client gives evidence that throughout the marriage, from very shortly after the younger child's birth, by agreement, she was the one looking after the children. She was the one who stayed home and devoted herself to the care of the children in the house, and effectively enabled the husband to go out and earn the amounts of money that he did, which then puts him in good stead to earn the same similar amounts of money now.
I just don't have any evidence as to
What he had in my client's affidavit, Your Honour, there is some evidence.
it's a statement.
There is a bit of limited evidence, but we have it before you in paragraphs 55 and 56. It's within her knowledge to make those statements, and therefore, as the only evidence we have in this matter, my submission is that it's strong evidence that you're able to rely on, Your Honour. She says that the company paid the husband between €6,000 and €8,000 a month, so €6,000 and €8,000 a month. And that the company earned $220,000 in consulting fees, an additional amount to Coming back to the effect of the marriage on my client's earning capacity, the absence for her from the workforce for such a length of time can only have a negative effect on her earning capacity. Subsequent to separation, she obtained work as a carer, which is a relatively unskilled position, and now works in office administration. She's detailed what her income is, and it's certainly not anywhere near what she says the husband's income was. Your Honour, another consideration of the Section 752 is the child support paid by child support paid for the children. Josephine is now over 18, but she was under 18 at the time of the separation. Joshua is still under 18. My client's evidence is that apart from 3 payments in November 2007, she's received no money whatsoever for the children. She has had to maintain the children since separation, and I think it's very clear. My submission is there is no hope that the wife will ever receive any child support for Joshua. Your Honour, turning lastly to Section 7520, I mentioned before the Cavalli principles in respect to wastage. Your Honour, the husband has engaged in conduct that I would submit falls within the Cavalli principles in relation to two items. That being the company. If Your Honour accepts or is willing to make a finding that it may well have had a value, then the husband's actions since separation have led it to now be dissolved and for it to have no value, one would assume, at all. In addition, Your Honour has evidence about the actions the husband took in relation to the controlled monies account. The sale proceeds from the sale of the Tenant Hills property were pursuant to orders of 16 June 2008 to be placed in the controlled monies account.
The best that they can get for that would be something like about 2 or 3%.
In a cash management account, it now has gone up previously, which is related to most of the period, would be about 3%. By my calculations, being that it's approximately 6 months, it would be around about $4,500. Your Honour, there's very clear evidence from the husband's emails in respect to the controlled monies. I can say that there was an attempt by my client to have the registrars sign the required documents pursuant to Section 106A. There was a difficulty in that regard as a result of the notation made by Judicial Registrar Johnston that the agreement that Watson Prey would keep it, the husband's former lawyers, was a notation only. That was therefore unsuccessful, Your Honour.
Probably brings it to an end.
Sorry?
That probably puts it to an end. Yeah, but if it's a notation only,
It's unfortunate that in what happened it was only notation. There was certainly no issue at the time, and it wasn't, that particular part wasn't drafted as consent orders, it was added by Judicial Registrar Johnston. Your Honour, turning lastly to justice and equity in respect to the property issues. While my client's application for effectively 83% of the assets is under what I have suggested might be the appropriate percentage for her, it is all that she can get. There is absolutely no point in making an order for the husband to pay her any money because I think we can all accept that simply will not happen based on the conduct of the husband to date. Your Honour, the husband has chosen not to give evidence today. It can be as a result of what can only be described his contemptuous attitude towards his court. That the husband is presented with that attitude should leave the court no concerns as to failing the husband in terms of providing him justice and equity. Your Honour, there are 2 additional orders sought that have only lately been sought in respect to parenting. Your Honour, that is sole parental responsibility and an issue about the passport. While sole parental responsibility should cover a passport, it's certainly my experience in the past with other clients that the passport office doesn't necessarily accept the sole parental responsibility order.
when does the child's passport expire?
The child passport expires in January, Your Honour.
Travels on an Australian passport.
He does, Your Honour. Your Honour, there has been no Section 60R certificate. My submission is that this is a matter where mediation is, the requirement for mediation should be waived because of the simple impracticality Your Honour, the husband, the only evidence I'm relying on in wanting to support the sole parental responsibility is the husband's own emails, where he refers to the children as his former children, and also makes a comment of the leeches called wife and children. The husband himself has disowned the children. I can say to Your Honour that those two emails that I provided you are not the only. There are only emails in that regard. There are numerous emails. But it's any point in tendering all of those for all the emails, Your Honour. Your Honour, those are my submissions. I do have an application in this at the cost, though.
I'm going to reserve Mr. Nolan, are there any submissions that you want to make?
David, I've asked you to call me Peter. Mr. Nolan is a corporate strawman of which I'm the primary creditor and secured party. For the record, are we on the record? I believe you have been recording, madam. I believe you have been recording.
No. What happens here, Mr. Nolan, is that all proceedings in this court are recorded.
Okay, so for and on the record. David, are you operating under your oath today?
Mr. Nolan, do you have any submissions that you wish to make?
For and on the record, David, are you operating under your oath today?
Take it that therefore you have no submissions that you wish to make.
So we'll let the record show that the Sovereign, Peter Andrew Nolan, has asked David twice, is he operating under his oath today? And David has refused to answer, is he operating under oath? It's my contention that he's operating as a private employee and therefore has no jurisdiction over my common law property rights.
There being no submissions, then I reserve my decision. I believe a written judgment on a date to be advised.
Well, David, should you choose to violate my property rights, let me hereby notice you that I will address those rights in a common law jurisdiction court. You may be charged with theft. You may be charged with violation of common laws. I have with me documentation to demonstrate that I am the primary creditor of the corporate strawman, Mr. Peter Andrew Nolan, and I have the highest claim. I have not been able to present this documentation because the magistrate is acting as a private employee of a private company, not as a common law judge. He is in fact impersonating a public servant.